People in the construction industry are in a little bit of a different situation where you can't just go and take back labor. If you paint a house, you can't go get the paint off the house. You can't get it back.
It starts with the contract. The next is to do good work, because without good work, the contractor is not entitled to much. Once you have the contract in place, that serves as your notice to owner. If you're in direct contract with the owner, you don't need a separate notice to owner because that statutory lien language serves as that.
Hello, this is Chip Bachara with Bachara Construction Law Group, a Florida law firm with offices in Jacksonville and St. Petersburg. And with me today is Hugh Higgins, managing partner of the St. Petersburg office. Hi, Hugh.
Hey, how's it going, Chip?
I'm doing good. So, Hugh, today, let's talk a little bit about what's near and dear to every contractor's or subcontractor or supplier's heart, and that is getting paid. That's why we're in business. That's why we do what we do. And so what we want to talk about today is what happens if you're not getting paid or if you don't get paid, because people in the construction industry are in a little bit of a different situation where you can't just go and take back labor. If you paint a house, you can't go get the paint off the house. You can't get it back. But Florida law protects contractors and subcontractors and suppliers with the law. So let's talk a little bit about that. So how does a contractor or a subcontractor or supplier protect its claim for payment when he or she is not paid for the work they performed?
In addition to just basic contract rights, the lien law is going to be the most powerful tool in contractor's tool belt. And in Florida, and as well as other states, the lien law is going to enable the contractor, if they follow the right steps to the T, to not only have the typical contract rights, but to actually place a lien on the property that the improvement was performed on, so that they can get paid based on the house or the property as a security for the amount that they were owed. And also trigger attorney's fees that were incurred in order to be able to get that payment.
So a claim of lien, while that term is generally known by contractors, what you're actually doing is you're putting a cloud on the title, as lawyers call it, or basically you're making a claim to some portion of ownership of that property. And that's really a rare right. Generally, the only people that get that right are the people who lend the money to buy the property, and that's their collateral, is that property, so they have the right to take it back. But contractors, subcontractors, and others that make improvements to real property are given by Florida law the right to put a cloud on that title that prevents owners from selling that property without you getting paid. So it's a strong hammer. It's a great deal of protection, but in order to get that protection, you've got to make sure you jump through all the hoops, and you've got to do that exactly right, or else you will have missed your opportunity and some other bad things can happen. Hugh, let's talk about what are those hoops that need to be walked through.
Sure, and you're right to say it's very detail oriented, because the way the statute is drafted, fancy words, the statute is to be strictly construed and strictly enforced, which essentially means because the contractor has these special lien rights, the contractor has to follow the statute to the T. Otherwise, the lien rights could be waived. And so to your question, what does the contractor have to do? Well, it starts with the contract. And is the contractor working directly for the owner and has a direct contract, or is the contractor a subcontractor of that?
Let's start with the contractor. If the contractor is hired by the owner of the property, what has to happen?
First and foremost, the contractor needs to put in the statutory lien language in the contract. That's prescriptive. It's exactly how the statute says it should be. And it either needs to be on page 1 of the contract, making it completely clear to the owner that the lien law applies to this work, or it can be on a separate page but there has to be a signature line on that page.
Right. In fact, I'm in the process right now of modifying an AIA contract for a large construction project, and we've had to insert that. We've inserted that language that Florida law requires onto a page within the AIA contract, and Florida law requires that that page be separately signed by the owner in order for the contractor to have done what they need to do to protect their lien rights. So that's the first thing that the contractor would do. What would come next for the contractor?
The next is to do good work. I mean, because without good work, the contractor is not entitled to much. So once you have the contract in place, that serves as your notice to owner for people that are familiar with the notice to owner language. If you're in direct contract with the owner, you don't need a separate notice to owner because that statutory lien language serves as that.
The owner knows that you're on the project and doesn't have to look out for somebody that they may not know be aware of. Well, let's talk a little bit about that notice to owner. Let's put that into context. That's a notice that subcontractors or suppliers, anyone providing improvements to the real property, has to serve, and that's a particular word that we'll talk about, a form that's called a notice to owner that notifies the owner of the property that says, hey, I'm providing materials or I'm providing labor services and materials to your project, to your property, and you need to make sure that I get paid because if you don't, you may wind up paying twice. And so that's what the notice does. It would say, hey, I'm ABC Supply or I'm ABC Masonry, and we're doing work for XYZ contractor on your property, and you need to make sure that we get paid. And so that notice has to go out. That has to go out 45 days from the first day on which you provided services on the property, or if you're doing what's referred to as special, if you're providing what are referred to as specially fabricated materials. That could be something like cabinetry or some type of piece of equipment that would only fit in that building. You couldn't take it out and go put it somewhere else, different than like an appliance. But let's use cabinetry, for example. If that especially fabricated material, that 45-day period starts from the date that manufacturing begins. So you may be on the job ahead of time doing measurements and that sort of thing, but it's the date of manufacturing that triggers that if it's specially fabricated materials. If it's not, then it's simply 45 days from your first day on the job, and you need to serve it by certified mail, return receipt requested. And so let's talk a little bit about that, Hugh. With regard to service, there's some particular language in the statute about that. Why don't you tell them about that?
Yes, there are a few different options in terms of how service is to be achieved, and you want to follow one of the prescribed methods of service. Sometimes people ask with regard to certified service, what if the recipient rejects it, right? Sometimes an owner either isn't there because the project's under construction, or they simply reject certified mail. The obligation is that the return of service from the Postal Service indicates that the delivery occurred or was attempted, etc. Whether it actually reaches the owner's hands and the owner accepts is not critical.
Okay, and then how does the entity that's serving the notice to owner, how do they know where to serve it and who to serve it on and which parties to serve it on for that matter?
You're going to want to look at the notice of commencement, which is a significant document. At the start of any construction project, an owner is required to record a notice of commencement in the public files, and that notice of commencement sets forth the key information regarding the project address, the owner name, the method to contact the owner, the prime contractor. If there's a bond in place, that should be reflected on the notice of commencement, and some other important information. So that is a document that every contractor should make sure they have in their file for projects they're working on and refer to it.
Yeah, that's an important document, and it's one that every subcontractor or supplier needs to be aware of and obtain that document. Those documents, the notice of commencement has a couple of functions. First of all, in addition to giving you all of the information about the property that you would need to know, what that document does is it allows everyone that's providing work on that project to have their claim of lien evaluated at the date of the notice of commencement, as long as the notice of commencement hasn't expired. Without getting into a lot of detail, because there is a lot of detail, I think what's important to note about a notice of commencement, other than the information that's in it, is that it typically lasts for 1 year. If there's no specified expiration date, it will expire 1 year from the date that it was recorded. If your project is going to last longer than a year, you're going to want to have that notice of commencement extended before it expires. So, and maybe even put in at the outset of the project that the notice of commencement expires, 2 years from the date of recording, or whatever date that you think it might be appropriate. There are a lot of details with regard to a notice of commencement. They are important. It's information that you should look into if you feel like you need to prepare a claim of lien or serve a notice to owner. So we would encourage you to do that. When you're in a situation where you need to protect yourself from getting for your payment and to recover payment, and you're not allowed to go and take back the work that you've done, if once it's incorporated to the property, you cannot do that under Florida law. That's a good time to call a lawyer and evaluate. Make sure the lawyer is evaluating the economics of the situation for you. We do that with every phone call that we receive, and we talk about the amount in dispute and what it might cost to do that. And I think it's important that happen. If you find yourself in that situation, give Hugh or myself a call. We'll be glad to help you out and get you set on the right track for recovering that payment. Thanks very much.